Do you know that USCIS has just implemented major groundbreaking changes regarding I-130 processing priorities that are set to take effect in February 2026? If you currently have a pending family-based immigration case, or if you hold the dream of bringing your loved ones to America, this breaking news has the potential to completely alter the course of your life. Over the next few minutes, I'm going to explain in full detail exactly how these changes will impact your personal situation and, more importantly, outline precisely what you must do right now to protect your future. Please do not make any decisions regarding your immigration journey without watching this video until the very end, because even one small mistake or oversight right now could push your case back by many months, or potentially even years. Hello everyone, and welcome to Entry Status USA, your most trusted and reliable source for the latest, most accurate, and critical immigration news. I'm your host, and today we are going to dive deep into a topic that is both urgent and incredibly important for every immigrant family. USCIS, the United States Citizenship and Immigration Services, has officially announced significant and far-reaching changes to the processing priorities for the I-130 petition for alien relative, starting in February 2026. These changes are not minor. They could affect millions of families who are desperately waiting to bring their spouses, parents, children, or siblings to the United States. If you also have an I-130 petition that is currently pending, or if you are in the planning stages to apply in the near future, then this video is absolutely vital for you to watch. So I request you to please stay with us and watch this video till the very last second. And if you find this information helpful, please hit the like button and share it widely so that more people can be made aware of this critical update before it is too late. At CHUM, Entry Status USA. Our mission is to always provide you with accurate, timely, and actionable information. So don't forget to subscribe to the channel and press that bell notification icon so that you receive every single update the moment we release it. So let's get started and truly understand what this I-130 priority shift actually means, how it works, and why USCIS has made this specific decision at this time. First, it is crucial to understand exactly what the I-130 form is and why it matters. Form I-130, officially known as the Petition for Alien Relative, is the foundational document that United States citizens and lawful permanent residents, meaning green card holders, must file to begin the process of bringing their family members to America. This is the very first and practically the most important step of the entire family-based immigration process. When you file the I-130, you are basically proving to USCIS with evidence that you and your foreign relative have a valid, bona fide family relationship. It is only after this petition is officially approved that your family member can move to the next stage of applying for a visa or proceeding with an adjustment of status. Now, let's talk about the complex world of priority dates and the visa bulletin system, because understanding this mechanism is very important to grasping the new changes. In the United States, there is a limited number of family-based immigrant visas available every single year, and these visas are distributed strictly based on different preference categories and the applicant's country of origin. When you file the I-130, you receive a priority date, which is usually the date USCIS received your application. This priority date effectively tells you what your number is in the waiting line. Every single month, the State Department releases a document called the Visa Bulletin that tells you which priority dates are considered current for which category and which country. When your specific priority date becomes current, only then can your family member proceed with the actual visa application. In some categories, such as immediate relatives, which means spouses of U.S. citizens, unmarried children under 21 of U.S. citizens, and parents of U.S. citizens, visas are always available, meaning they are always current. But in other categories, such as F2A, meaning spouses and unmarried children under 21 of green card holders, F2B, meaning unmarried sons and daughters over 21 of green card holders, F3, meaning married sons and daughters of U.S. citizens, and F4, meaning brothers and sisters of U.S. citizens, the waiting time can be excruciatingly long. This is especially true for certain countries that have a high volume of applications, specifically Mexico, the Philippines, India, and China. Now, let's come to the main point of today's discussion. What exactly has changed for February 2026? USCIS has announced that they are fundamentally shifting their processing priorities to improve overall service and aggressively reduce the massive backlog. Previously, USCIS generally processed cases on a first-in, first-out basis, meaning whoever filed their application first was generally processed first. But now, they have decided to move away from that model and will instead prioritize certain specific categories and urgent situations over others. Under this new priority system, priority number 1 goes to immediate relative petitions, the IR categories. These will receive the absolute highest priority. This means that cases involving spouses, unmarried children under 21, and parents of U.S. citizens will be processed before anyone else. This decision was made because visa numbers for immediate relatives are unlimited by law, and by processing them quickly, USCIS can ensure that these families can be reunited faster without being stuck in a queue behind capped visas. The second priority category is dedicated to aged-out cases and serious humanitarian situations. If a child is on the verge of turning 21 years old and aging out of their eligibility while the petition is pending, or if there are serious medical emergencies, cases of domestic violence, or other critical humanitarian concerns, such cases will also be pulled to the front of the line and prioritized. The Mansea. Third priority is assigned to employment-based cases that are related to family-based petitions, where the employer is cooperating more effectively and the case can be resolved quickly to benefit the economy. The Sataya. Fourth priority will be given to cases where an RFE, request for evidence, or NOID, notice of intent to deny, has already been responded to, and the case is technically decision ready. USCIS wants to clear these off their desks. And finally, routine cases where there are no special circumstances will be processed after these priorities are met. This priority shift implies a serious consequence. If your case is not in the immediate relative category, your processing time may become even longer than it is today. Specifically, there will be more significant delays in the F2A, F2B, F3, and F4 categories. Historically, these categories already suffered from very long wait times. For example, the F4 category, meaning brothers and sisters of U.S. citizens, already has a wait time of more than 15 to 20 years for applicants from some countries. Now, after this priority shift, this wait time may increase even further. The F2A category, which covers spouses and children of green card holders, is also now expected to face more delays. Previously, the wait time for this category was approximately 2 to 3 years, but now experts fear it could go up to 4 to 5 years. Similar increases are expected in the F2B and F3 categories as well. Now, the most critical question arises. What should you do in this situation? How do you protect yourself? The first and most important thing is, don't panic. These changes are definitely challenging and stressful, but if you make smart, calculated decisions and do proper planning, you can navigate your case successfully. Step 1. If you haven't filed the I-130 yet and you are eligible, file as soon as possible. Do not wait. The priority date is established from your filing date. The sooner you file, the sooner your priority date will be locked in and your place in the queue will be confirmed. Every single day of delay can increase your eventual wait time further. This is especially important for people who are going to apply in preference categories, meaning F2A, F2B, F3, or F4. Step 2. The second important step is to file your petition, absolutely accurately and completely. The cleaner and more error-free your petition is, the fewer chances there will be that USCIS will send you an RFE or NOID. If USCIS sees any deficiency in your documents, or if any information is unclear, they will pause your case and request additional evidence from you. This process can take months, pushing your case further back in line. So, when you're filing the I-130, prepare every document properly. Your relationship proof should be undeniable. If you're petitioning for a spouse, submit wedding photos, joint bank accounts, lease agreements, utility bills in both names, communication records, and other evidence that proves your relationship is genuine. If it's a parent-child relationship, include birth certificates, adoption papers if applicable, and other supporting documents. Financial documents are also important, especially regarding the I-864 Affidavit of Support. Keep your tax returns, W-2 forms, pay stubs, and employment verification letters ready. Step 3. The third important point is that if your case is already pending and you have received an RFE or NOID, submit its response completely before the deadline. USCIS has clearly stated in this new update that cases where an RFE has been responded to and the case is decision-ready will receive priority. So if you submit your response quickly and accurately, your case can jump into the priority queue and be processed faster. Don't take any shortcuts in the response. Whatever additional evidence or explanation USCIS has requested, provide it thoroughly. If needed, take the help of an immigration attorney so that your response is strong and convincing. Step 4. The fourth step is to consider naturalization. If you are a green card holder and eligible, this is a very important strategic point. If you are a permanent resident and it has been 5 years since you received your green card, or 3 years if you are married to a U.S. citizen, you can apply for U.S. citizenship. After getting citizenship, if you have a pending petition for your spouse or unmarried children under 21, it will automatically convert to the immediate relative category. This bypasses the waiting list and makes processing much faster. Similarly, if you have a petition for your parents and you become a citizen, they will also move into the immediate relative category. So, naturalization can significantly speed up your family's immigration process. Step 5. The fifth important action is to regularly check your case status and maintain communication with USCIS. Create an online account on the USCIS website and regularly log in to check for updates. If your address changes, immediately inform USCIS by filing Form AR11. If any notices or requests are mailed to an old address and missed, your case can be denied. Also, stay in contact with your attorney or representative if you've hired one. They can guide you on exactly what steps to take and when. Step 6. The sixth step is to explore alternative options, if possible. For example, if you are a green card holder and have filed an F2A petition for your spouse, consider whether your spouse is eligible for an employment-based visa. If a U.S. employer can sponsor them for an H-1B, L-1, or other work visa, you can try that option in parallel. This way, if the family path is slow, the employment path remains open. Similarly, if you have children who are close to 21 and at risk of aging out, check the Child Status Protection Act, CSPA, provisions. CSPA protects children from aging out in certain situations. Discuss with your attorney whether CSPA applies to your case. Step 7. The seventh and very crucial step is to maintain updated documentation. As time passes, your life circumstances may change. If your marital status changes, children are born, you move addresses, your income changes, or any significant life event happens, maintain proper documentation of it. When your case finally comes up for an interview or final processing, all these updated documents will be needed. If you don't have current documents at that stage, there may be even more delays in processing. Step 8. The eighth step is to seriously consider attorney consultation. Immigration law is very complex and every case is unique. A qualified and experienced immigration attorney can analyze your specific situation and suggest the best strategy. They can also tell you whether an expedite request is possible in your case or whether other options are available. Many people think attorney fees are expensive, but the time and money wasted from one mistake or missed opportunity can cost much more than attorney fees. So, this investment is worth it for you and your family's future. Step 9. The ninth important point is to regularly monitor the visa bulletin. Every month, the State Department updates the visa bulletin. In this bulletin, you can see how priority dates are moving for your specific category and country. This will give you a realistic idea of approximately when your priority date might become current. The visa bulletin has 2 charts: final action dates and dates for filing. The final action date tells you up to which priority date visas are actually being issued. Dates for filing tells you up to which priority date people can submit their applications. Follow both dates closely, and as soon as your date becomes current or near current, start your preparation immediately. Step 10. The 10th step is to kailangan do emotional and financial planning as well. Family separation is very difficult, especially when the wait time is so long. Maintain regular communication with your family members through video calls, messages, and when possible, plan visits to keep the relationship strong. Also, plan financially because the immigration process has fees, attorney costs, medical exams, travel expenses, and other costs. Set your budget accordingly. If you are the financial sponsor, maintain your income and assets at a sufficient level because in Form I-864, you have to meet specific income requirements that are equal to or more than 125% of the federal poverty guidelines. Step 11. The 11th step is to avoid fraud and scams. When people are desperate or frustrated with delays in their case, they become easy targets for scammers. If anyone promises you that they can expedite your case through some special connection or by giving money under the table, be immediately alert. There are no shortcuts other than USCIS's authorized processes. Only hire licensed attorneys or accredited representatives. You can verify on the Board of Immigration Appeals website whether an attorney or representative is legitimate or not. Share your personal and financial information only with verified sources. Step 12. The 12th and very critical step is to document humanitarian circumstances if applicable. If there is a serious medical emergency in your case, a situation of abuse or domestic violence, or other exceptional and compelling humanitarian reasons, prepare proper documentation. For medical emergencies, you need detailed letters from doctors that explain the severity of the condition and specifically mention that the beneficiary's presence in the United States is medically necessary. In abuse cases, police reports, protection orders, medical records, and statements from counselors or social workers are helpful. For these humanitarian requests, you can submit an I-130 expedite request with supporting evidence. USCIS reviews each expedite request individually, so it's important to present a comprehensive and compelling case. Step 13. The 13th step is to take timely action for aged-out protection. If your children are approaching the age of 21 and your I-130 petition is taking time to be approved, it's important to take advantage of Child Status Protection Act, CSPA provisions. Under CSPA, in some situations, the child's age can be frozen or adjusted. But for this, you have to follow a specific timeline and submit proper documentation. Late action can cause this benefit to be missed, and the child can age out and shift to the preference category, which means many more years of wait time. Step 14. The 14th important consideration is to understand country-specific backlogs. Applicants from China, India, Mexico, and the Philippines especially have to face more backlogs because more applications come from these countries. Due to per-country limits, applicants from these countries have to wait significantly longer than applicants from other countries. If you're from these countries, have realistic expectations and plan accordingly. Sometimes looking into cross-chargeability, claiming the specific country of your spouse, can help legally if citizenship of another country is involved. But this is a very complex legal area, and professional advice is necessary. Step 15. The 15th step is to do advanced preparation for the interview. When your priority date finally becomes current and a visa interview or adjustment of status interview is scheduled, you should be completely prepared. In interviews, the consular officer or USCIS officer verifies the genuineness of the relationship, performs a background check, and confirms eligibility. Keep all your original documents organized: relationship proofs, financial documents, police clearance certificates, medical exam results, and whatever required documents there are. Keep everything ready. Practice for interview questions. Common questions include how you met, your relationship timeline, family background, future plans, and financial situation. Giving truthful and consistent answers is very important. Providing any false information can lead to serious consequences, including a permanent bar on entry to the United States. Step 16. The 16th consideration is to Follow pending legislation and policy changes. Immigration laws and policies sometimes keep changing. New administrations, court decisions, or congressional legislation can bring changes in processing priorities, backlogs, or eligibility requirements. Regularly follow reliable sources like Entry Status USA so that you stay updated. Sometimes positive changes also come that can benefit your case, such as special provisions to reduce backlogs or initiatives to improve processing time. Step 17. The 17th point is to consider alternative family members filing petitions. If multiple family members are U.S. citizens or green card holders and are eligible to file petitions for the same person, they can all file. For example, if a beneficiary's brother who is a U.S. citizen has filed a petition in the F4 category, and later his sister also becomes a U.S. citizen, she can also file a new petition for the same brother. This way, multiple petitions can be pending, and the beneficiary can proceed through whichever becomes current first. Many families use this strategy to have multiple chances and backup plans. Step 18. The 18th step is that the beneficiary should also remain active in their home country. The beneficiary should also do preparation from their side while waiting. Educational credentials, employment records, police clearance certificates, medical records, and other documents should be kept organized and updated. They can also gather information about the U.S., improve English language skills if necessary, and generally remain productive in life. All these factors create a positive impression in the interview and strengthen the case. Step 19. The 19th important factor is to have patience and persistence. The most difficult thing in family-based immigration is the long wait time. Being away from your loved ones for years is emotionally and practically challenging. But if you have followed the right process and done everything properly, eventually your case will be processed and your family will unite. During that time, maintaining a positive attitude, keeping hope, and moving step by step towards your goals is important. Many families have gone through this difficult journey and have successfully reunited. Your case will also be successful if you keep putting in consistent effort and follow proper guidance. Step 20. The 20th and last actionable step is to seek community support. You are not alone in the immigration journey. There are many support groups, online communities, and local organizations that help immigrants and their families. Joining these communities gives you emotional support. Information is shared, and sometimes you also get valuable advice from other people's experiences. Churches, mosques, community centers, and immigrant advocacy organizations also provide resources. Use these resources and build a network. So, friends, these were the detailed main points you should understand about USCIS's February 2026 I-130 priority shift. And these were the comprehensive steps you should take to handle your case in the best possible way. I know this news is frustrating, especially for those people whose cases are already pending in preference categories. But remember that with proper planning, accurate documentation, and timely action, you can improve your situation. Every case is unique, so make decisions according to your specific circumstances and take professional help when needed. So friends, this was today's important information about USCIS's latest I-130 priority shift. I hope this video was helpful for you, and you got a clear, detailed picture of what you should do. If you have any questions or want to discuss your specific situation, definitely write in the comment section. I and Arcetesto. Entry Status USA. Team, read your comments and try to provide helpful information as much as possible. But remember that information given in comments is general guidance and not legal advice. For your specific case, always consult with a qualified immigration attorney. If you found this video helpful, please press the like button and share with your friends and family members who are also going through the immigration process. By sharing, you can help others avoid mistakes too. And if you haven't subscribed to the Matre Geeks Entry Status USA channel yet, subscribe now and press the bell icon so that you get notification of every new video. We regularly bring United States immigration and visa-related updates that can be very important for you. Friends, the immigration journey can be long and challenging, but with the right information and proper guidance, you can achieve your goals. Entry Status USA is always with you in this journey. May God give you all success and may your families unite as soon as possible. Take care and see you in the next video with another important update. Stay informed and stay blessed.